I'm Shanna Welsh-Levin. I am your Southern California real estate attorney with SoCal Realty Law. We protect real estate investors and real estate professionals. We provide a wide range of landlord comprehensive legal services, and there are not very many firms in town that provide this kind of service that we provide to landlords. You might ask why not? And you will find out while we do this webinar. The reason that a lot of people don't want to touch landlord-tenant law right now is because it is driven by statutes. It is highly technical and constantly changing. It is also hyper-local because we have local ordinances coming up from one city to another, and other kinds of parties that get involved with landlord-tenant relationships like HOAs. So a lot of attorneys will stay away from landlord-tenant law, but we dive right in, and I keep myself and my team up to date by doing these monthly webinars and presenting them to you as a value add if you are a client or you know us and you're on our email list. So very happy to provide the information. I want to make sure you understand that it is not to be considered legal advice. The information I'm giving is not associated with any particular set of facts or circumstances. And when I do answer questions at the end, please understand that if we get into too much detail, I'm going to have to cut it off and recommend that you contact me directly or contact us, my team directly, so that we can get the information that's needed and apply the law to the specific facts. So I'm just providing you with general legal information, but it's not to be construed as advice. I've been an attorney for 18 years. I've only practiced real estate law in my career, and I have a lot of experience with various areas of real estate law. In addition to landlord services, we also do litigation such as fraud litigation. We handle buyer-seller disputes. We do quiet title, and also we do some real estate transactions. So today is part of our Landlords Need to Know series, our monthly Landlords Need to Know webinar series, and we're going to do the legal update. And at the end, if there's time, we will do Shanna versus the Chat GPT or the chat bot. All right, most important issue right now is this upcoming change to the law in the city of San Diego. And I know some of you may be from outside the city of San Diego. A lot of what's going on in the city of San Diego is being echoed by other cities around the state and within the county of San Diego, like Chula Vista has a new ordinance we'll talk about a little bit. The law has changed in Los Angeles as well. So we're going to touch on other areas, but we're diving into the city of San Diego's new proposal. So to begin, current law in the city of San Diego has not changed yet. But the new law has been voted on, and it is coming up for a second reading on May 16th. And it's my understanding that upon the second reading, that is when the law officially passes and takes effect 30 days after that. So after it passes, it takes effect 30 days later. The dates are not written into the current version of the new San Diego ordinance because it hasn't passed yet. So those will all be filled in. The current law in San Diego is the tenant's right to know regulation. Sorry, that's misspelled. It's the tenant's right to know regulations. And I also call it the Fair Renter Ordinance. Under the Fair Renter Ordinance, the protections become effective. The protection of the tenant becomes effective after the tenant has been in the property for 2 years. The city council and the mayor's office, when designing the new law, state that they believe that the statewide rent cap just cause law, the AB 1482 that passed in 2019, became effective in 2020, they believe that that law was not effective in the city of San Diego because we had a pre-existing local ordinance that protected tenants. But in my office and my understanding of other attorneys, as we apply the law, we apply the California rent cap and just cause law along with the city's tenants' right to know regulations. And that's because the statewide law was more protective than the local law. And so when I analyze and apply the law, I always apply the more protective law. And that's usually how it works. That's usually the right way to go. But the city has justified this change in the law by saying that they believe that their tenant protection law was not strong enough and needed to be strengthened because the state law was not applicable in the city. The new law is taking the place of the old law. So the city is enhancing tenant protections, focusing on no-fault evictions and relocation assistance, but also doing a bunch of other things. And they are removing the tenant right to know regulations and putting a new law in place, which is called they're calling it residential tenant protections. So a lot of the new residential tenant protections mirror the California rent cap and just cause law, with certain additions that make it more protective than the statewide law. And so in particular, I'm going to go through the law in order and try to help summarize it and help organize it. Also, I wanted to point out that the other justification for the law is obviously the high numbers of homeless people in the city of San Diego. We have the point in time count that happens every year. The 2022 point in time count found over 4,800 individuals living on the street. And then they found a record high number of people experiencing homelessness in downtown San Diego in January 2023 at 1,939 people. That's really significant. And I am an advocate to try to help people find permanent housing. And even though that kind of contradicts what I do for a living, which is we do evictions and we help landlords, I also do some work on the other side of things, which is to try to find transitional housing for people who are experiencing homelessness. So I do understand the issues behind this, and I agree that something needs to be done. But in my opinion, they are just overcomplicating the situation. And when I talk to landlords, it is often the point of discussion that a landlord today feels compelled to get as much out of their property as they can, to increase the rent to get more money out, because the risk has gone up. And when risk goes up, the cost to the person who's taking on the risk goes up. So the risk is going up for landlords, and they feel compelled to be compensated for that, or at least to have some reserves just in case they have to evict someone or deal with all of these, this hire an attorney to deal with the complication of evicting a tenant. So one of the changes in the new law that is different from the rent cap just cause law is that once it takes effect, the protections protect the tenant immediately when they move into a property. The statewide law only takes effect after the tenant has been there for 12 months. But in the city, this law will take effect immediately. The city's prior law, as I mentioned, would take effect only after the tenant had been in the property for 2 years. So that's a pretty significant difference. The exemptions under the type of properties that this applies to are the same, but if you are exempt from the California rent cap and just cause law, you are also going to be exempt from the new City of San Diego protections. However, when you're exempt from the statewide law, you have to claim the exemption. You have to have certain language in your lease that states that notifies your tenant that your property is exempt from the rent cap and just cause law. So in the City of San Diego, if you're exempt, you also have to add language to your lease or send a notice to your tenant claiming the exemption, notifying them that the property is exempt. And there's different language for the city of San Diego that must be used in addition to the California statewide rent cap just cause exemption. So that is something that needs to be done within 90 days of the passage of the law. There is also some, sorry, I'm getting through this. The exemptions include hotels. So exemptions mean that these are types of landlords and properties that will not be subject to the new law. Hotels, vacation rentals, affordable housing. It says housing subject to an agreement that provides housing subsidies for affordable housing for persons and families of very low or moderate income. But this exemption does not include Section 8. So Section 8 tenancies are not subject to it. I don't know whether VASH vouchers, those kind of subsidies might be subject to this or not. And that's something that we need to look into. Also exempt are mobile homes and institutions and facilities such as nonprofit hospitals, religious facilities, extended care facilities, licensed residential care facilities for the elderly, or nonprofit transitional housing. Dorms are exempt. And then we have the owner-occupied exemptions when the owner is renting up to 2 bedrooms or ADUs. So an owner-occupied property that is a landlord is renting out bedrooms in their home up to 2 bedrooms, or you have a home with 2 ADUs or junior ADUs on the same parcel, that those would be exempt. And then the single family residence exemption, which needs to be claimed. Duplexes are also exempt, and properties that are less than 15 years old. So a lot of this should sound familiar if you're familiar with the California law. But as I mentioned, there's an additional notice of exemption that must be given to the tenant, special language, and then for tenancies existing prior to January 1st, 2024, the notice that's required in the city may be provided in the lease, not must, it may. But for tenancies commenced or renewed after January 1, 2024, the notice shall be included in the lease. One of the free resources that I'll provide to you is I'm going to give you the language that is required, and also some other items that we'll talk about when we get to them. So as far as terminating tenancies, this is where, sorry, make sure I'm staying with my slides. So yeah, so as far as terminating tenancies, there are a lot of similarities and some particular differences. So we have at fault termination, which means that the tenant is at fault. And then we have no fault termination, where the tenant is not at fault and the landlord has some other reason to terminate the tenancy. Either way, the landlord has to provide an approved just cause for the termination. So at fault is, fairly easy. You know that a tenant's at fault and can be evicted if they stop paying the rent, or if they breach a material term of their lease. If they are committing waste, meaning they're damaging the property significantly, or they are causing a nuisance, they are using the property for an illegal purpose, or if their lease terminates. And so many tenants have a 1-year term on their lease. If the term ends, meaning, they lease the property from March 1st, 2021 to April 30th, 2022, you cannot simply evict them because on April 1st, 2022, their term has ended. Under the new law and for non-exempt properties in California, the landlord has to offer a new lease in writing with similar terms. And then if the tenant rejects that offer and doesn't sign the new lease, then the landlord can proceed with an eviction. So that constitutes at fault just cause. Criminal activity, criminal threats, assigning or subletting in violation of the lease, refusing to allow the landlord to enter the premises after the landlord gives notice and has a justified right to enter, using the property for an unlawful purpose, similar to using committing crime in the property, or where the tenant is an employee, agent, or licensee of the landlord and fails to vacate after the employment has ended, or the tenant has already agreed to a move-out date in writing and fails to move out as agreed. So then we get to the no-fault reasons, and this is where we have some pretty significant differences. So some of the similar ones are that the landlord seeks to recover possession to occupy the property by themselves, their spouse, their domestic partner, or child by blood or adoption, or grandchild, parent, or grandparent. But there are some changes to this, some additions to this. So for leases entered into after the effective date of the law, they're going to fill in the date. This is one of the blanks in the current version. The landlord can only take possession for this reason if the tenant either agrees to the termination in writing, or if the lease expressly allows the landlord to terminate the lease. So what we'll need to do is adjust leases in the city of San Diego to state that the landlord may terminate the tenancy if the landlord wants to use the property for their immediate family. And that can only be done when the tenant is on month-to-month or at the end of a term of their lease. Just keep that in mind. You can't interrupt an ongoing term of a lease for the landlord to move in. The other reasoning provided is, so it provides that the landlord can, upon renewing the lease or issuing a new lease, can include the language where the landlord can terminate the lease to move in or have their family moved in. So that'll be an important adjustment to make. Another another no fault just cause is that the landlord seeks to recover possession to withdraw the residential rental property from the rental market. There's no specific time attached to this statement as far as how long the property has to be withdrawn from the rental market. I've gone several rounds of trying to figure out what a reasonable time is. I would say a year. Chula Vista's new law says 2 years. It's a little bit unclear. Another no fault just cause is that the landlord seeks to recover possession to comply with orders issued by government agencies, any kind of order to vacate the property. However, if the government agency or the court determines that the tenant is at fault for the conditions that require the tenant to vacate, then the tenant shall not be allowed any relocation assistance. We'll get to the relocation assistance part of this, but for a no fault eviction, if the tenant is not at fault, they are entitled to relocation assistance under both California law and now, once this takes effect, under the new San Diego law. But San Diego is providing for more relocation assistance than the California law provides for. A substantial remodel is one of the no fault reasons for terminating the tenancy. Substantial remodel is defined in the California law. It's not as carefully defined in this law, but this law says that in order to recover possession to demolish or substantially remodel the property, the landlord has to do all of the following. They have to post at the property the application for the necessary permits within 3 business days of submitting the application. So this is before you issue any notice to the tenant to terminate the tenancy. First, you have to notify the tenant that you are applying for the permits. Then you have to secure the necessary permits and then serve a copy of the necessary permits with the written termination notice. Certified under penalty of perjury, stating the reason for the termination. You also have to describe in the notice of termination why the work cannot be reasonably accomplished in a safe manner with the tenant in place, and why the work requires the tenant to vacate the property for at least 30 days. So that is different. That's new. None of the other laws that I've seen require all of that information to be disclosed to the tenant, not to mention the preliminary act of giving the tenant a copy of the application for the permits and then giving them copies of the permits after they've been received. All right, so then as far as the additional requirements, so we have new notices that need to be given to residential tenants. And these are notices that need to be given to all tenants within 90 days of the new law passing. Sorry for the typos on my slide. But there's an additional notice that has to be given to the tenant, as well as a tenant protection guide that has not even been published yet, as far as I know. The guide will be published by the San Diego Housing Commission, called the Tenant Protection Guide. And then the notice will state that California law limits the amount that your rent can be increased. See California Civil Code section 1947.12 for more information. Local law also provides that a landlord shall provide a statement of cause in any notice to terminate a tenancy. In some instances, tenants who are seniors, 62 years or older, or disabled, may be entitled to additional tenant protections. See Chapter 9, Article 8, Division 7 of the San Diego Municipal Code for more information. So that's the quote, all the way through where it says San Diego Municipal Code for more information. This is not language that is included in any of your rent cap just cause addenda or disclosures that you've already given to tenants. This is new. Then the landlord shall include a copy of the tenant protection guide with this written notice. The commission, meaning the San Diego Housing Commission, shall prepare and make available on the commission's website a tenant protection guide, which shall include educational information and resources for the tenant to understand their rights. And the notice, as I mentioned, shall be provided to the tenant directly or as an addendum to the lease within 90 days of blank. So 90 days of probably when this law passes, or potentially when that tenant protection guide becomes available. So once the tenant protection guide becomes available, I'll make sure to download it, and in future webinars, I'll give that to you as a free resource, and we'll go over all of this again after the law passes, so you can just come back. And I know this is probably for many of us, including myself, going right over my head, but we'll absorb it, digest it, and give it back to you again in hopefully a more organized fashion. All right, then we have requirements upon termination for at-fault just cause. So we went through all of the at-fault causes, but there are new rules in the San Diego law for giving the notices of just cause for at-fault evictions. So within at-fault eviction, you almost always, with certain exceptions, you have to give the tenant a right to cure. So this is for any curable termination reason. You have to In San Diego, you now have to give 2 notices. One is an early notice with the right to cure. That would be a 3-day pursuant to Code of Civil Procedure 1161 subsection 3. That's the 3-day notice to cure or quit. And then if the violation is not cured within that time period, the landlord may terminate the tenancy without any further opportunity to cure by serving a 3-day notice to quit. The landlord is also required to give notice to the San Diego Housing Commission. And it states that this section where you have to give notice to the commission shall not apply until 30 days after the commission establishes a submission portal and provides public notice of its creation. So they've got some work to do to provide this tenant protection guide and this new portal. Then for the no-fault eviction notices, you give the notice to the tenant, whether it's a 30 or a 60, you know, it's 30 days if the tenant has been there less than a year, 60 once they are there for 1 year or more. And the landlord must provide the basis for termination, which we always recommend across the board, even if you're not subject to any rules relating to providing the cause for the eviction. I still recommend that you always provide the basis for the termination of the tenancy. It avoids any claims of retaliation by the tenant. The notice shall also state the tenant's right to relocation. And we haven't talked about the relocation requirements yet, but the landlord has the right to choose whether the relocation assistance will be paid by direct payment to the tenant or by a waiver of rent. The new requirements for relocation assistance are either 2 or 3 months of the actual rent in the city of San Diego. And so if you give a 30-day notice and you have to give 2 months of rent, you're not going to be able to simply waive the rent. You're going to have to at least pay something directly to the tenant for the other 30 days, for the other month of rent that needs to be given to them as relocation. And then you could waive 1 month. If it's a 60-day notice, you can just waive 2 months of rent. So the landlord has to notify the tenant what they elect to do. And a new item is the tenant's right to an offer to renew the tenancy if the property comes back on the market within 5 years of the termination. In order for a tenant to take advantage of this, the tenant has the obligation to notify the landlord in writing within 30 days of the termination notice of the tenant's desire to receive an offer to renew the tenancy. They must provide the landlord with a mailing address or email address where the offer can be sent. And then they have to provide the landlord with any change of address as time goes on. So the no-fault just cause evictions also require notice to the San Diego Housing Commission through what will be their new portal. And now we have the relocation assistance turn. So I've already kind of given you most of this information, but the 2 months of relocation assistance applies to most tenants. So the city of San Diego now requires direct payment or waiver of up to 2 months of rent. But if the tenant is senior or disabled, then the payment shall be 3 months of actual rent. Okay. Now, if you have more than one tenant named in the lease, so you've got multiple people named in the lease and you don't know who to pay as far as the relocation assistance, the landlord is allowed to make a single direct payment to all of the tenants named in the lease. The waiver of rent doesn't need to be directed to any particular tenant, but if it's a direct payment, it can be a check with all of their names on it, or a money order. Okay, and if you owe any other kind of relocation assistance, then the amount that the city of San Diego requires is credited toward that. So you don't have to pay this in addition to the California relocation assistance. No, it would still just be 2 months, even if you're not exempt from the California relocation assistance. And then if the tenant fails to vacate after expiration of the notice, then the landlord may recover the relocation assistance from the tenant. So that means that the tenant is no longer entitled to the payment. The payment would have already been made, or the waiver of rent would have already been completed. So the landlord now has to get the relocation assistance back from the tenant, probably through the unlawful detainer process, by obtaining a money judgment against the tenant and then collecting the money judgment. All right, so for let me just make sure I'm not missing anything in here. It reiterates this procedure where if the property goes back on the market within 5 years and the tenancy was terminated for no fault of the tenant, then the tenant has to notify the landlord that they may want to, that they do want the offer to take possession again within 5 years. If the tenant is going to take possession again, the landlord still has the right to screen that tenant using industry accepted methods and shall communicate the minimum screening criteria in the written offer for the new tenancy. So then the tenant has 30 days from the date of receipt of the offer to accept. And the landlord doesn't have to offer the property for the same terms as the prior tenancy. They can bring the rent up to fair market value, and we'll have to look into that if there are any other restrictions for what the offer can or cannot include, but I believe it would just be like renting to a new tenant. All right, so we've got this new thing in here, more new stuff. Very interesting. Some provisions for buyout agreements. Buyout agreements, we often call those cash for keys agreements or move out agreements, where the tenant is going to accept money in exchange for terminating their lease early, or moving out sooner than they would otherwise need to. There are 2 different kinds of buyout agreements. The definition of a buyout agreement here is a cash for keys agreement. Well, this is my definition. A cash for keys agreement prior to filing an eviction lawsuit. And the provisions for buyout agreements for the city do not include settlement agreements where an eviction has been filed and the tenant agrees to move out during the eviction process. So this is prior to any eviction taking place. The landlord is required to first make a written disclosure to the tenant prior to making a buyout offer. So the landlord shall provide each tenant a written disclosure that includes a statement that the tenant has the right to not enter into a buyout agreement, that the tenant may choose to consult with an attorney before entering into a buyout agreement, that the landlord may not retaliate against the tenant for refusing to enter into or negotiate a buyout agreement, and a statement that all tenants of the property may refuse to receive a future buyout offer by providing the landlord written notice of their refusal, which shall be effective for 6 months. And then they can also rescind their statement that they don't want to receive any future buyout offers. So this is, I think that this is something that is in here to avoid harassment of tenants, to avoid landlords who go back to the tenants over and over and over again, trying to negotiate a buyout agreement because they really want the tenants to move out. And this allows the tenant to give the landlord a statement that they don't want to talk to the landlord about a buyout agreement anymore. In addition, the disclosure to the tenant has to include a statement that the tenant is eligible for relocation assistance and the amount of the required relocation assistance. It has to state the names of all people authorized to discuss a buyout offer on the landlord's behalf, such as the landlord's attorney or property manager. And it has to have a space for each tenant to sign and write in the date that the landlord provided the disclosure, as well as a space for the landlord to sign and write the date that the disclosure was provided. So, free resource for today will also include our draft of this disclosure. And the way that I think I'm going to do it is I'm going to have the disclosure, and then I'm going to have the next thing, which is the buyout agreement, what I would draft as a buyout agreement. So there are 2 documents now required by the city, but once this passes, will be required by the city. If you want to approach your tenant about a buyout agreement, you have to do this disclosure in writing, and then you provide the buyout agreement in writing. But the provisions for the buyout agreement are very specific. The landlord has to provide first the fully executed copy of the disclosure form within 3 days of its execution, and then the buyout agreement shall be in writing. The copy shall be given to each tenant at the time that the tenant signs the buyout agreement. That means each individual tenant. I would assume this means adults. The buyout agreement shall include the following statements in at least 14-point font: that the tenant, quote, you, the tenant, have the right not to enter into this buyout agreement if you, the tenant, are entitled to relocation assistance under federal, state, or local law. A buyout agreement for less than the amount of relocation assistance to which you are entitled violates Chapter 9, Article 8, Division 7 of San Diego Municipal Code and is void. You, the tenant, may choose to consult with an attorney before signing this agreement. And then if the tenant primarily negotiates the buyout agreement or lease orally or in writing in a non-English language, so if the landlord and the tenant communicate in some language other than English, then the landlord shall provide the tenant with translated versions of all of these things. And then if the buyout agreement doesn't strictly comply with this, it would be void. So, in case you didn't catch it, the buyout agreement is required to provide the amount of money to buy out the tenancy that is greater than the amount of relocation assistance that the tenant is entitled to. It says greater than. I read it as greater than or equal to, because then the next statement is that the buyout agreement for less than the amount of relocation assistance would be void. So if less than is void, then equal to or greater than would not be void. That's my interpretation. And you can't write any kind of waivers of other rights into the buyout agreement. It has to, you can't put like a, we like to include sometimes a release of all claims, or maybe a hold harmless or an indemnification provision in some relocation assistance agreements, or some cash for keys agreements. And this is saying that you can't waive or limit a tenant's rights under this buyout agreement. All right, so then the statute, moving on from the buyout agreement part of the statute, the next part just states that a landlord shall not retaliate against a tenant for exercising any right provided by this new law. And then it provides remedies. So the remedies are really the teeth. The remedies are not part of the California rent cap just cause law. That law was written and doesn't have any kind of attorney's fees provision or punitive damages provisions in it if you violate it. Basically, if you violate the California rent cap just cause law, you just can't evict the tenant, or there can be other problems that arise, but it doesn't give the tenant a treble damages provision or attorney's fees. So the remedies here under the City of San Diego new law would provide the tenant a private right of action for wrongful foreclosure. That means that the tenant could sue the landlord for violating this law. Many laws are written that don't provide a private right of action, and so the law is out there but can't be enforced by the beneficiary of the law. In this case, they can. So you can expect tenants to file wrongful eviction. I wrote foreclosure. I'm sorry, I was putting this all together at the last minute, but wrongful eviction action for any violation. Then we have treble actual damages. So that would be like the tenant's moving expense. That's what comes to mind, that they would get 3 times. Treble means 3 times whatever the tenant is awarded as damages. In addition to the actual damages, the court issues punitive damages for 3 times that amount. The tenant is also entitled to triple the relocation assistance that they should have received if the landlord fails to provide relocation assistance, as well as their attorney's fees. All right, so that is pretty much it. As I mentioned at the beginning, that this law would go into effect the 30th day after its final passage. And I think that would be May 16th, 2023, when the second reading is scheduled. All right, so that's the big stuff, but a bunch of other new laws are in place as of May and some of them prior months. So short-term residential occupancy licenses are now required in the City of San Diego as of May 1st, 2023. If you're doing rentals for less than 30 days, vacation rentals, you need to have a license. There are 4 different kinds of licenses. If you want to know more about that, we've done prior webinars about that, or feel free to call us and we'll let you know what you might be eligible for. A lot of those licenses have already been given and they are limited in number. Some of them are limited in number. So I'm not sure where we're at as far as how many have been given. All right, then the County of San Diego is currently under a state of emergency. This is not, in my opinion, not such a big deal right now because it'll be over unless it's extended. It'll be over by May 20th in, less than 10 days, but it's due to the storms. On April 20th, the governor declared the state of emergency, and it triggered the price gouging protections. Price gouging protections under the California Penal Code, Section 396, include a cap on rent increases at 10%, among other things. It also includes some prevention from eviction. You can't evict someone and then re-rent the property for more than it was previously rented for. There are exceptions to these rules if you can justify the increase. It also applies to other things like through October 17th, the price gouging protections will be in place relating to construction, labor, and materials, or services, reconstruction services. Let me just read it to you. It's unlawful for a contractor to sell or offer to sell any repair or reconstruction services or any services used in emergency cleanup for a price of more than 10% above the price charged by that person for those services immediately prior to the proclamation or declaration of the emergency. And these protections have been put in place in many counties throughout the state of California. There is a website, the California Office of Emergency Services, www.caloes.ca.gov, and then you go to Office of the Director, /policy administration, /legal affairs, /price gouging. And there is a table with all of the counties that are subject to the price gouging statute and an explanation of why and which portions of the statute apply. So that's very helpful if you're concerned about it. All right, County of Los Angeles had a eviction protection law in place that protected tenants from eviction that had COVID hardship, but it seemed like it applied to basically any tenant eviction if the tenant was being evicted for non-payment of rent. So the tenant had to claim a COVID hardship in writing, and related to that, if the tenant was going to pay back the rent, then the landlord was obligated to cooperate with a payment plan. So that expired, but as of March 31st, 2023, when it expired, the new law that went into place is that for any non-payment of rent eviction against a tenant that claimed a COVID-related financial hardship, you have to give 30 days notice. Just for the record, the way that we apply this kind of law, because the claim of COVID hardship can be so ambiguous, and the way that it's claimed and the way that it's applied by the court, we are recommending doing a 30-day notice instead of a 3-day notice for non-payment of rent or any kind of financial notice to a tenant that might result in an eviction. Better safe than sorry. The Chula Vista Municipal Code, we've done this one on a prior webinar. I'm not going to go into a ton of detail on this one. It is complicated, but the highlights and the things that kind of reoccur in my world are the right to receive the future rental offer, similar to what City of San Diego is putting in place in Chula Vista. The Chula Vista ordinance became effective March 1st, 2023. And goes through January 1st, 2030. So for multifamily properties, meaning a rental complex with 3 or more rental units, the notice to the tenant has to include the right to receive a future rental offer. They require 2 times the amount of what the HUD determines to be the fair market rent for most tenants, and 3 times the fair market rent for anyone who is elderly or disabled. If it is not a residential rental complex, meaning it's less than 3 units, that's not exempt from the Chula Vista law, then they require only 1 month of relocation assistance. So that's for exempt properties though. So if you're sorry, that's for not exempt properties. So the many properties, if you're exempt from California rent cap just cause requirements, then you would probably also be exempt from the Chula Vista Municipal Code requirements. And Chula Vista also has this requirement that the city be notified if a no-fault eviction is initiated, and then they also specifically say that if the reason for the no-fault eviction is withdrawal from the rental market, the withdrawal has to be at least 2 years. They added a very specific definition of substantial remodel. In particular, this $40 per square foot of the residential rental unit. So the cost of the improvements have to be equal to or greater than $40 per square foot of the unit. Permits must be obtained, and you have to justify that it's necessary for the rental unit to be vacant for more than 60 days. 60. San Diego is only 30, but Chula Vista is 60. All right, and the Chula Vista ordinance also includes all sorts of enforcement penalties, a private right of action for the tenants to sue the landlord. The city attorney can enforce it, as can the City of San Diego. City attorney can enforce the San Diego rules. Statutory penalties, attorney's fees, and even criminal penalties in Chula Vista. All right. So another hot topic this month, which I can't actually answer the questions yet because we don't know it yet. In April, so in May, we're supposed to find out what the rent cap adjustment will be that becomes effective for August of each year. So under the California rent cap and just cause law, every year for properties that are not exempt from the law, landlords have to know what their cap is. And the maximum amount of rent increase would be 10%. The rent cap cannot exceed 10%. It has to be 10% or less. And it's based on 5% plus the percentage change in the cost of living. So this is the definition of percentage change of cost of living. I'm not going to read it for you, but complicated. But you basically take last year's cost of living, the difference between this year's and last year's, and the difference is added to 5%, and that becomes your new rent cap. It's based on April's calculation, which we should know by the end of May. And then once that calculation is out, I will make sure to include it on our next webinar and post it on social media and try to get the word out for whatever the rent cap is. If I had to guess, I'm not going to guess. I have a guess, but I'm not going to share my guess just in case I'm wrong. All right. So some timelines for unlawful detainers these days, and I am running out of time. We always track how long it's taking for the court to enter judgments and issue writs of possession. So if you are evicting someone and you are getting a default judgment against your tenant for possession only, as of today, they are working on things submitted April 11th. So it's taking about 4 to 5 weeks. For court judgments, defaults that include both possession and money. So if you want your money, it has to go through the court. Those take a little bit longer. They're about 6 to 7 weeks. As of today, they're working on things that were submitted March 21st. And then if you actually go to trial, then that's the quickest turnaround for the court. Post-trial judgments are taking only about a week, and that's pretty awesome. Although if you stipulate and your tenant agrees to move out by stipulation and avoid trial, then you're on the court judgment timeline. All right, we're going to skip the Shanna versus ChatGPT today. I'll have to use that one for next time, and I apologize. What I was going to share with you, and I'll share it really quickly in case you're curious. I went through the California Association of Realtors lease, which is the one that I primarily use. I also have my own versions, but I love the car form lease. It's, in my opinion, it's my favorite. And then I went through what ChatGPT spit out at me when I asked it for a California lease, to draft me a California lease. And then I went through the Rocket Lawyer one that you can get for free online. And you can see that the car lease has a lot more to it. It just goes on and on and on with all sorts of things and all the statutory disclosures that California requires, which there are tons of required statutory disclosures now. Those are all automatically included in the car form lease. And you can see that you should not get your lease from an online source because they just don't have everything that you need. ChatGPT was miserably deficient, and Rocket Lawyer also does not give you a lot of the things that you need for compliance with California law. All right, so I'm going to stop the share now and look at some of the questions that we have. One question, do the ADU exemptions have to be noticed to the tenant? I think interpreting this question, if you have a tenant living in an ADU, do you have to provide all of these new exemptions, notices, and disclosures that we just talked about? And the answer is yes. A tenant is a tenant, and depending on where your property is located, you have to comply with all the laws, even if it's an ADU. And then what reasons are acceptable to enter the property with reasonable notice? Written 24-hour notice. The California civil code has a list of applicable reasons why you can enter a property or give a tenant notice. If you use the California Association of Realtors lease, it has those reasons written into it. Off the top of my head, actually, here, I will tell you. Entry. I have a copy of the California Association of Realtors lease. For the purpose of making necessary or agreed repairs, including but not limited to installing, repairing, testing, and maintaining smoke detectors and carbon monoxide devices, bracing, anchoring, or strapping water heaters, repairing dilapidation relating to mold, decorations, alterations, or improvements, or supplying necessary or agreed services, or to show the premises to prospective or actual purchasers, tenants, mortgagees, lenders, appraisers, contractors, and others. So one thing that's specifically excluded from this list is entry for inspection alone. And I have seen a lease that includes entry for inspection as a reason, but be aware that inspection alone is not generally included in the list of things that you can issue a 24-hour notice of entry. All right, has the list of family members that are approved to be moved into the rental in case of no fault eviction changed? No, it hasn't. It's always been this list of children, parents, grandchildren. It was what I read. Let me find it. But no, I do not believe that it's changed. Oh, namely our siblings going to be included. And if not, can no fault eviction be filed before the law goes into effect? Let's see, what does it say about siblings? "28 pages, guys, the ordinance that I was reading to you. So let me. Those are the exemptions. Where's the no fault? No fault, just cause. Seeks to recover possession to occupy the residential rental property for a landlord or their spouse, domestic partner, child by blood or adoption, grandchild, parent or grandparent. Yeah, so that does not include siblings. And I do not think there are going to be any significant changes to the new law in the city. And then I have, let me see if it's still up. I have the California rent cap just cause. And I can tell you what it states, but I have to log in again. So give me just a second. I knew there would be a question on this, so I pulled it up, but my system logged me out before. Anyway, I believe it is the same in the California statute. It's not letting me log in. Shoot, that's because I'm on Zoom, so it's not going to let me. I will try to look that up in a moment if the system changes here. All right, sounds like a good time to sell property. Yes. In the city of San Diego. Yeah. Or if you have the opportunity to raise the rent or change your lease in the ways that I would recommend. I think it is a good time to make some adjustments. Okay, so if you have a tenant who's very difficult with this is the next question. If you have a tenant that's very difficult with various items and the lease comes up, if you are exempt from just cause requirements, can you just not renew the lease for no reason? And then are relocation fees required to be paid to the tenant? So if you are exempt from all of these rules and regulations, you can notify the tenant that they are expected to move out when their lease comes to an end. But it is highly recommended that you notify them of that. If they've been there more than a year, I recommend giving at least 60 days advance notice. If they've only been there 1 year or less, then arguably you could just give 30 days. The more notice you can give, the better. Most tenants expect that they'll be able to stay beyond their initial lease, but if you're not going to let them stay, just make sure to give them written notice. In California, you might be able to get by if you're exempt without giving notice, but I won't take a case without giving notice. If you came to me on the first day after the lease has expired and you say, can you file an eviction? I will tell you no, unless you have written notice to the tenant and you're exempt. And are relocation fees required if you're exempt? No. So if you're exempt from these rules, you're exempt from having to pay relocation. But we do take it on a case-by-case basis in determining whether properties are exempt or not. And there are other rules that apply sometimes. Under single family exemption, does any of this apply? So, you know, the single family exemption is the main one. And so it would not apply. If you're, what I would recommend is that you have an attorney look at it and determine the exemption. I know that a lot of realtors also understand how to determine whether a property is exempt, and then the CAR form has all the provisions to help you determine that. I still think that it's important to have an attorney take a look at this before you take any action. Okay, so oh, we have a new judge in Department 501 downtown. That's the department that does evictions. So that judge is constantly changing, and my paralegal is just notifying me of that in case anyone is interested. Okay, so for the city of San Diego, if you want to remodel a 4-unit apartment building, you have to give the tenants a 6-month notice in addition to posting the permit, etc. 6 months. I don't think 6 months is what's required. Once the law changes, what it says is you have to give them a copy of the application and then receive the permits. If that takes 6 months, then I see where you might be coming from here, because I know it can take a while to get those permits. So maybe if you consider giving them the application notice, which, yeah, I guess that is. So once this law goes into effect, you do have to start the process much sooner if you expect to be able to evict the tenants due to a substantial remodel. Would something like a 6-month lease prevent any of these things? No, in the city of San Diego, once this goes into effect, these rules are effective immediately when the tenant moves in. I'm going to make myself not blurry. Hold on. Okay, so as soon as the tenant moves in, once this law becomes effective, they receive all of these rights. And that's different from the statewide rent cap and just cause law, which only becomes effective after the tenant has been there for 12 months. Okay, are there new wrongful eviction issues with the new San Diego laws that we need to worry about? Yes, absolutely. The specific remedy included in the new law is a private right of action for the tenant to sue, and treble damages, 2 different treble damages, one for actual damages and one for unpaid relocation assistance, plus attorney's fees. Going forward, is there no practical way to enter into a 1-year lease absent the tenant voluntarily moving at the term or some just cause? I'm not sure that I understand that question. You might, maybe you can clarify for me, who the person who asked that question. Can you clarify what you mean? Is there no practical way to enter into a 1-year lease absent the tenant voluntarily moving at the term? Oh, okay. I think I understand what you mean. Like, you can do a buyout agreement. So, you know, under the new provisions, and there are other areas where you can you can avoid these kind of rules. Maybe maybe the point is to buy property, sell property in areas subject to these rules, and buy property in places that aren't subject to these rules. Okay, where can we find all the reasons for a property being exempt? So other freebie I'm going to send you is the proposed ordinance. And it has all of those reasons listed. So you'll be able to find them they're buried in here. It's so hard to find anything in here because it's 28 pages long, but the exemptions, do you mean the exemptions from the ordinance? Those are on page 7. So the proposed section 98.0703 lists all the exemptions. All right, you're all very welcome. I think I'm done. I'm going to keep going through the questions. I'm almost to the end. Can we still adjust a deposit to equal 1 month's rent along with 10% rate increase for a duplex in San Diego? There's no change to the way that security deposits are handled under this law. The relocation assistance is paid in addition to any refund of a security deposit. As far as adjusting the deposit when you increase the rent, yes, you can do that under a notice of change in terms of tenancy. You cannot charge more than 2 times the monthly rent for an unfurnished unit and 3 times for a furnished unit. I hope that hasn't changed. This is my recollection of what the law says. Yeah, hopefully that answers your question. If someone wants to remodel a house, then sell it. Is that just cause? Maybe, depends on how extensive the remodel is. Those are 2 different reasons. So one is remodeling, substantial remodel. Another would be withdrawing from the rental market. So a lot of times the owner wants to withdraw the property from the rental market in order to sell it vacant. The complicated and difficult to answer question that arises when you are removing a tenant just to sell the property is, how long does it have to be removed from the rental market, and can the buyer put it back on the rental market right away? And that is not clear under the law. So can you do a lease with a strict termination at the end of 1 year? You can have a lease that states that the tenant is not to hold over. If you want to enforce that, you have to take active steps to enforce it, because California law says that, if a tenant holds over and you accept rent for the month following the lease termination, then you have started a new tenancy. It also, California law allows a tenant to hold over. And if you don't give the tenant notice that they are expected to leave at the end of the lease, which, the lease arguably did give them notice, but I recommend giving additional notice. It's important to be very clear with tenants about the expectation to leave the property. It's clear and in writing. So, and we will, hey Jess, can you see in the chat that there's an email address, a change of an email address for someone who wants the video sent to a different email address? Yes, we will help you out with that.
I can't see the chat. Shanna, can you send that over to me?
Oh, okay. Yeah, I will copy that. All right, that's all I've got for you guys today. And let me know if you have questions. Feel free to call the office and we'll do our very best to help you out. Also, feel free to come to the next webinar. Thanks, everybody.